Hi everyone, it's Dr. Marks, and our topic for today is the Ecuador versus Texaco Chevron lawsuit. Now, you've already watched the movie Crude. At the end of the movie Crude, which was released in 2009, we are left waiting for a verdict. And so in 2009, none of these lawsuits, and there's actually a whole collection of them, had really come to fruition. So we're waiting at the end of the movie to learn what has happened. So this presentation is going to explain the legal cases surrounding Chevron. Now, it's going to get a little confusing, I'm going to admit. So let me just make sure you're clear. It's important to note that, first of all, there are multiple cases, and we're going to talk about a number of them. And there are legal battles both inside and outside Ecuador. So this is not just a lawsuit that takes place inside Ecuador, but that is the primary one. And to make it more complicated, there are lawsuits that are taking place simultaneously. So I'm going to do my best to try to give you a good overview of all of this. Now, my objectives here, number one, I want you to understand the players, who's involved, and number two, understand the timeline. Now, I don't mean that I want you to go memorize all of the dates. Please don't do that, but try to get a sense of how things unfolded. We have to cover some key legal concepts here. Now, I'm not a legal scholar, but my good friend Dr. Carver is, and so she and I put this together. The bulk of it came from her, and then I did some refinements. So if there are any really specific questions about the legal stuff, I'm probably not your girl, but Dr. Carver can help us. Now, as I said, it's a bit messy, it's a bit complex, and you are not expected to memorize these dates. So please don't waste your time memorizing these dates, but you do need to have a general understanding of the events, a pretty good understanding of these events. So let's start off by talking about the players. In 1993, and that's an important year to note, so you do need to know that year, Texaco leaves Ecuador, and Ecuador takes over drilling in the Amazon. Okay, so 1993, Texaco says, "See ya, Ecuador, I am out of here." Now, who's Ecuador? Ecuador is a national entity, so it's basically government. It's a government sponsored oil company. Okay, so Ecuador. Now, 1993, Texaco leaves, but Chevron merges with Texaco in 2001. Now, this is also a fact I'm going to expect you to know. So, while I just told you you don't have to memorize all these dates, there's some that you are going to be responsible for. So, Chevron merges with Texaco in 2001. Now, think about that. Texaco has not been operating in Ecuador for 8 years when Chevron merges with Texaco, okay? So while Texaco operated in Ecuador, Chevron never did. So when we see references to Texaco Chevron in Ecuador, remember, it was really Texaco. It's just that Texaco has been absorbed by Chevron. Now, one important thing is that acquisition of Texaco means that the Ecuador situation becomes Chevron's problem. Unfortunately for Chevron, they can't just say, hey, this wasn't us, this was Texaco. Well, they absorbed Texaco, which means they have absorbed Texaco's problems as well. So the lawsuits that we're going to talk about are with Chevron. But understand they're with Chevron, but because of actions of Texaco. So it's not actually Chevron that's accused of the damage, but they are the ones involved in the lawsuit. Okay? All right, so let's get started with a legal overview. So Texaco has left 1993, absorbed by Chevron in 2001. Everything is now Chevron's problem. All right, a legal overview. Now, 1993. Ecuador versus Texaco is filed in the Superior Court of New York. 1993. Again, why is that a key year? That's the year that Texaco left Ecuador. So big lawsuit, Texaco leaves. Now, in 1995, just a couple years after Texaco left, Texaco agrees to clean the oil pits in Ecuador for $40 million. Now, I have personally seen some of these oil pits, and by now I'm sure I've shown you some pictures, but we're basically talking about small little ponds, mini lakes that collect all of the hazardous waste from the production process. And it's basically in the ground. There's a thin liner. They're not covered up until, much later. They leak into the groundwater. They're open, so it affects the, air. But anyway, Texaco agrees that they're going to come in and clean up all of these oil pits in Ecuador for a sum of $40 million. Now, in exchange, Ecuador says, great. And they agree to indemnify Texaco. All right, so in exchange, Ecuador agrees to indemnify Texaco. Now, what does that mean? Ecuador indemnifies Texaco. Well, what it means is that Texaco is protected from all future lawsuits in Ecuador. So it's like they come to some kind of agreement and Ecuador says, okay, we're good with this. You don't have to do anything else. Texaco is essentially off the hook for everything else. Now, in 2002, the United States courts dismissed the case in New York, stating that Ecuador is a better venue for this legal battle. So in 2002, now notice, remember, 1993 is the original filing of the case, right? 2002, the courts finally say, you know what, this should not be heard in New York. It should be heard in Ecuador. So everything changes. But in 2001, remember, Texaco was acquired by Chevron. So from now on, I'm going to be using Chevron. Maybe occasionally I say Texaco, but really it's Chevron's problem. Okay, so things move to Ecuador. In 2003, because the courts in New York said, hey, this needs to move to Ecuador, in 2003, Ecuador versus Chevron is refiled in Ecuador. All right, so see if you can follow this so far. 1993, lawsuits filed in New York, but then Texaco, who was originally being sued in 1993, is acquired by Chevron. So now it's Chevron's lawsuit, and New York says this doesn't need to be filed in the U.S. It needs to be filed in Ecuador. Everything moves to Ecuador, but instead of Ecuador versus Texaco, it's Ecuador versus Chevron. All right. Now, in 2009, Chevron files for arbitration at The Hague. Now, what am I even talking about? Well, The Hague is an avenue for binding arbitration. You've probably heard the term binding arbitration. So binding arbitration, we're going to talk more about it, but it's where parties get together and they come to a binding conclusion without going to court. So it's kind of an out-of-court settlement. Later, that same year, in 2009, Chevron v. Ecuador is filed in the Superior Court of New York. All right, so now Chevron suing Ecuador. Then in 2011, Chevron sues Donziger. Now, who's Donziger? Well, he's the New York lawyer for Ecuador, and you saw him in the movie Crude. So we've got years of lawsuits going on, right? The original lawsuit was 1993, refiled in Ecuador, and now Chevron's suing Ecuador, and now Chevron is suing Donziger, the lawyer. So this is an interesting situation. The 2011 case, Chevron v. Donziger, again, it's a lawsuit, but it was just days before the verdict for the big case was expected to come out. So some people say, hey, this is Chevron being strategic, that we're about to get a verdict on the big case between Chevron and Ecuador. So right before we expect that, we're going to sue Ecuador's lawyers. So remember, Donziger is the lawyer from New York for Ecuador. February of 2011, we have a verdict in Ecuador versus Chevron. All right, been a long time coming, right? Now, let's talk about that a little bit. Remember, this is the big lawsuit. This is the really big lawsuit that we've been talking about. Now, in 2011, Judge Zambrano issued a verdict in favor of Ecuador. All right, so this is great news for Ecuador, right? The plaintiffs were awarded $8.6 billion in damages. And on top of that, Chevron was ordered to pay an additional amount of money for cleanup. On top of that, Chevron was also instructed to apologize for the damage to the Amazon. So make a public apology. Apologize to the entire country for all the damage. Of course, remember, it wasn't caused by Chevron. It was actually caused by Texaco. But Chevron has absorbed Texaco, so it's their problem now. And if Chevron failed to apologize, then the plaintiffs would be awarded $19 billion. All right, so we're talking about some pretty big numbers here. So this is the result from the big lawsuit, and Ecuador has won. Of course, if you think it stops there, you're absolutely wrong. It's going to go on and on and on. But the initial award goes to Ecuador. Ecuador's won, and Chevron has lost. Now, Chevron chooses not to apologize. Why might they choose not to apologize? Well, it wasn't just PR. It was actually, part of their legal strategy. An apology can be used in a court of law as an admission of guilt. So if Chevron were to say, gosh, we apologize for what Texaco did, that could be perceived in a court of law as them saying we're guilty. Now, Dr. Carver makes a great analogy. This was, her analogy, and it's great. Think about driver's education classes. Students are taught to never say, I'm sorry. So you get in an accident and you don't say, I'm sorry, or even ask how the other person's doing. And the reason for that, it's been a long time for me, so I don't remember that, but the reason for that is that it causes an adversarial environment from the start. It can be considered as an admission of guilt. If I, get out of my car and say, I'm sorry, then it might be perceived as I'm saying, I know this was my fault. Of course, this can hinder amicable settlements or out-of-court settlements. So, Chevron does not want to say, I'm sorry, because then that can come back to bite them pretty big. Somebody's going to say, oh, Chevron was guilty. They apologized. All right, you get the idea. Now, in February 2011, Chevron's ordered to pay the $19 billion, right? Remember what I had just told you. If Chevron didn't apologize, they'd have to pay an additional $19 billion on top of the damages of $8.6 billion. So Chevron just is going to have to pay that money. In addition, remember, the cost of the cleanup. So if we add this together, the total judgment in this big lawsuit is approximately $27 billion. Now, Chevron has some deep pockets, but that is an enormous sum of money. Am I right? So, guys, what do you think Chevron's going to do? Do you think they're going to say, oh, wow, this really stinks, but we'll pay you the money? No, of course not. We know what's going to happen. They're going to appeal. So that's exactly what Chevron does. They appeal the verdict in Ecuador. Remember, this big lawsuit is in Ecuador because originally it was filed with Texaco in New York, and the New York courts said, you know what, this doesn't belong in U.S. courts. It has to go to Ecuador. All right, so Chevron appeals the verdict in Ecuador. Now, 2012, an Ecuadorian provincial court of justice upholds the verdict in the case. So Chevron appeals the 2011 ruling, and 2012, it's upheld. Later that year, Ecuador rules that Chevron has until the end of the day to pay the $19 billion verdict. The end of the day. That's pretty funny, right? So Chevron is still basically losing, but they're in Ecuador, right? 2013, It's gone all the way up to the Supreme Court, and the Supreme Court upholds the 2012 ruling. Okay, so Chevron has appealed this all the way up to Ecuador Supreme Court, and Chevron has lost every time. One small win for Chevron, however, and that is that the judgment was reduced because the court limits the payment to $9.51 billion. So if you can think of that at all as being a win, there's a little bit of a win for Chevron there. But Chevron is not winning its appeals, but it does successfully get the judgment reduced. All right, so we have some other things we need to talk about before we move on. But this was the major lawsuit. So let's just one more time recap because I know this gets very confusing. 1993 is the original lawsuit, but let's make sure we can answer these questions. Who was it with? It was with Texaco. Where was it filed? New York. Then later, Chevron absorbs Texaco. The lawsuit's refiled in Ecuador, but of course it has to become Ecuador versus Chevron, right? Okay, you get the idea. Now let's talk about some legal concepts that are important in going through the rest of the cases. So, 3 big concepts related to law and the judicial process. The first is legal arbitration, so we're going to talk about that. The second is U.S.-Ecuador bilateral treaty. What is this treaty? What does it do? How does it affect the lawsuits? And 3, judiciable. What does it mean if something is judiciable? Now, all of these are relevant in determining the outcomes of the legal battle. So we're going to go through these 3 things. Let's start by talking about legal arbitration. When people go to arbitration, that's when both parties agree to have the case reviewed by an arbiter. Now, who is an arbiter? He's not a judge. An arbiter is someone whose job it is to try to find a common resolution without a trial. So this is somebody who's going to be trained. He's going to be, smart, know how to handle the kind of process of arbitration, but he's not a judge. Now, arbitration can be binding or non-binding. So if it's binding, it means you and I sit down and we agree to whatever the outcome is with the arbiter, that will be binding. Or it can be non-binding where we're going to sit down with the arbiter, but I don't have to agree to it if I don't like. The problem here, the bilateral treaty that we're going to talk about in just a moment demands that arbitration be binding. So, binding arbitration is going to be what's relevant here. The problem is that there's no real enforcement mechanism. There's no real enforcement ability here. So, when we talk about going to the court of arbitration, it's going to fall short when it comes time to enforce the outcome. All right, so now we're at the Permanent Court of Arbitration at The Hague. And this is a place that you can go, big entities go, to try to come up with a resolution rather than going to court. The Court of Arbitration at The Hague was founded in 1899, and in 2015 it had 117 members. And as what we've basically just been talking about, it provides services for the resolution of disputes. Now, this is going to involve various combinations of states, state entities, intergovernmental organizations, private parties can go to the Permanent Court of Arbitration at The Hague. All right, so that's enough on arbitration. Let's talk about the idea of the bilateral treaty. Now, officially, the treaty we're talking about is called the Investment Treaty with the Republic of Ecuador. This dates back to 1993, but it really wasn't entered into force until 1997. So what exactly is this investment treaty with the Republic of Ecuador? What this treaty basically says is the follows. It outlines that each country will treat the other's companies equally with their own. So you can't treat another country's companies different than you treat your own. And that includes non-interference in the operations of companies within their borders. So if an American company is operating in Ecuador, they have to be treated just like an Ecuadorian company, and the government can't interfere in the operations of this American company. So they're basically kind of setting some rules. You want to come and open up a company in Ecuador, you're going to have some protections because of this investment treaty with the Republic of Ecuador agreement. All right. Another thing that this treaty does is outlines the dispute settlement. So what happens if there happens to be a dispute between parties? Now, one key issue of this bilateral treaty, government cannot sue the foreign company operating on their soil. Okay. Well, that seems very relevant here. Let's look at that again. Government cannot sue the foreign company operating on their soil. So the government of Ecuador can't sue a foreign company that's operating in Ecuador if it's part of this bilateral treaty. Well, isn't that exactly what's going on with the lawsuit that we've been talking about? So, last thing, this bilateral treaty also requires that disputes are settled quickly. So, there's a bilateral treaty that defines the rules of the game. If an American company or French company or German company that's part of this treaty operates in Ecuador, the government can't interfere. It has to treat it the same as Ecuadorian companies. The government can't sue. There's got to be some way of settling disputes that's already articulated, and they have to be settled quickly. So, the United States government cannot sue an Ecuadorian firm that's operating in the United States, right? So if Ecuadorian firms want to come to the U.S., our government can't sue them. And obviously the reverse is true, and that's really the key thing, right? The reverse is that the Ecuadorian government can't sue an American firm. So, the Ecuadorian government cannot sue American firms operating in Ecuador. So make sure you totally understand that point. So there's a bilateral treaty between the U.S. and Ecuador, right? And it's very clear. Ecuadorian government cannot sue an American firm, and Chevron is an American firm. But, and this is important to remember, individuals can sue. So, as part of this bilateral treaty, the Ecuadorian government can't sue an American firm, but individuals can sue. So, Miguel Rodriguez from Ecuador can sue an American firm operating in Ecuador if he's Ecuadorian. Also, other firms in Ecuador can sue. So individuals can sue, other firms can sue, but government cannot sue. So Chevron operating Ecuador as part of the bilateral treaty can't be sued by government, but it can be sued by individuals and it can be sued by other firms. All right, so that's enough on the bilateral treaty. You get a sense of why that would be very relevant, right? The last topic we want to talk about is judiciable. What does it mean to be judiciable? When something is judiciable, we're talking about generally in this context a law that's capable of being judged, especially in a court of law. So something's got to be capable of being judged, especially in a court of law. That means there has to be some actual case and some controversy. Okay, sounds like in this case, certainly there's a case and a controversy. It's got to be ripe, which means it's ready to be addressed. It's not something that should be delayed. It's moot, meaning it remains unsettled at this point. So again, it's ready to be addressed. The time is now, and we still have something that's unsettled. So it's ripe, it's moot. And there's got to be something to lose or gain. Got to be something to lose or gain. Now, there's one problem. Only a person can sue for themselves. And what we mean by that, if we say only a person can sue for themselves, no one else can sue for them or on their behalf. Okay? In other words, only the injured party can sue for themselves or legal guardians. Now, there are some exceptions. You're probably thinking, well, what about children? Well, that's a great exception. So some exceptions exist. You can sue for your child. You can sue for your parents if you have power of attorney. So there's some exceptions. But generally, when we're not talking about these exceptions, only the injured party can sue for themselves. So I can't sue for Dr. Carver, for example. Dr. Carver can't sue on my behalf. Only the injured party can sue for themselves. Well, who has the right to sue on behalf of the environment when it's injured? Who has the right to sue on behalf of the environment when it's injured? Well, that's unclear. No person or group are the actual injured persons. So if we're trying to talk about damage to the environment, now we can talk about how people might have been affected later. But if we're talking about the environment being injured, no person or group are the actual injured persons in that case. So they cannot sue on behalf of the environment, and the environment can't sue for itself, right? No one has legal authority to do so on its behalf. So, I keep using the Lorax, I speak for the trees. Well, when it comes to the lawsuit, no one can speak for the trees, and that's a problem. You can speak for yourself, you can speak for your kids, you can speak for your parents, but I can't sue on behalf of the trees. The environment can't even indicate what it wants, right? It's, in a sense, non-communicative. So the environment can't even indicate what it wants to happen. So when we think about legal standing, nobody has the ability to sue on behalf of the environment. Problematic. All right, let's go back to arbitration. As the trial in Ecuador is in progress, so now we're going backwards a little bit. So we're back to the big trial, which we've already talked about the outcome being appealed. 2009, Chevron filed 2 international arbitration claims. Now remember what I said, there are lawsuits taking place at the same time. So the big lawsuit, Ecuador v. Chevron, that's the big one that was being heard in Ecuador, filed originally in New York with Texaco, moved to Ecuador, but in 2009 it's not settled yet. So Chevron files 2 international arbitration claims while the big lawsuit's going on. They were heard in the Permanent Court of Arbitration at The Hague. So we've already talked about what is the Permanent Court of Arbitration. Remember, it's where the parties get together with the arbiter, and so this arbitration expert's going to try to come up with some kind of settlement without going to court. There are 2 key issues here. Well, issue number 1. Ecuador violated a U.S.-Ecuador bilateral treaty in the Ecuador v. Chevron lawsuit, right? So, why is that? Can you remember? What did we just talk about here? Well, remember we talked about the bilateral treaty saying that if you're Ecuador's government, you can't sue American firms operating in Ecuador. That's part of the bilateral treaty, right? So Chevron should be free from any government litigation as a result of the treaty, right? Part of the treaty specifically says governments can't sue companies, from the United States because the U.S. and Ecuador are in this bilateral treaty. All right. So, in 2011, the arbitration panel issues an interim measures order. What is an interim measures order? Well, basically, it requires Ecuador to suspend all enforcement of the verdict because it violates this bilateral treaty. So, this order requires Ecuador to suspend all enforcement of the verdict, right? It's just not going to work. So the plaintiffs can't enforce the judgment in Ecuador or any country outside of Ecuador. So basically, even though Ecuador kind of won the big lawsuit, by winning the big lawsuit, they violated this bilateral treaty. So this is really good news for Chevron, am I right? I mean, Chevron's been saying, hey, wait, we're part of this bilateral treaty and you can't do this. And finally, they get that support. Okay, so good news for Chevron here. Now, in 2011, another tribunal found that Ecuador's courts violated the bilateral treaty in international law. There had been decade-long delays in ruling on certain commercial disputes between Texaco and the Ecuadorian government. Now remember, what was something else we learned about the bilateral treaty? That there had to be kind of quick remediation, like quick settlement of disputes. But here, again, the bullet says decade-long delays in ruling on certain commercial disputes between Texaco and the Ecuadorian government. Well, so now we have kind of two things related to the bilateral treaty. First, governments can't sue American companies operating in Ecuador. And two, the bilateral treaty said you got to do things quickly. And there had been decade-long delays. So this was considered interference in the judicial process. So these two things are kind of thought about separately. But long delays, that was judicial interference. It violates this idea that they have to move quickly and they shouldn't be interfering in the operations. All right. Now we're in 2012. The panel meets to review compliance, and the panel determined that Ecuador has not complied with their order to stop enforcing the judgment against Chevron. Okay, so the panel, remember, they were the ones that on the previous slide said, hey, you can't enforce this judgment because of the bilateral agreement. And they wait, and they're finding that Ecuador is still enforcing the judgment against Chevron. So the panel says, hey, you're in violation of what we told you to do. On the previous slide, we just told you that you can't enforce the judgment against Chevron, but you're continuing to do so. This illustrates the problem in international law in that there's really no enforcement mechanisms. How do you get Ecuador's government to stop enforcing the judgment against Chevron? Well, who enforces that? That's the part that's missing. Now, while arbitration was binding, because remember we talked about that it was required to be binding, there was nothing forcing Ecuador to adhere to the panel's ruling. So things are starting to get really messy. All right, now we're in 2015. The panel held that the treaty between Chevron and Ecuador did not preclude residents from suing over the pollution in the future. So make sure you understand what that says. Remember, government can't sue Chevron, but residents can sue Chevron. So the panel basically said, hey, the bilateral treaty's clear. Government can't sue Chevron, but Ecuadorians, they can sue Chevron. So individual families in indigenous villages can sue. Okay, well that's a win, right? But we have a problem in that Ecuador's a poor country, especially the indigenous communities. And when you go into the indigenous communities, you really get a good sense of that. So, who's going to have the resources to go up against Chevron? That's going to be problematic. Also, you must be able to present damages. Remember when we talked about judiciable, there must be something to win, something to gain. There's got to be some damages. So imagine these indigenous family members. They're going to go up against Chevron. They have no resources and they have to present damages. Well, when big companies go up against each other, for example, the Exxon Valdez, Alaska had to show damages. Well, there were tons of studies done. So there has to be a dollar value in order to measure the compensation that's needed. The indigenous people can't just say, our kids are getting sick. Our water quality has gone down. They have to be able to put a dollar value on that. And that's a pretty sophisticated task. So this is going to require sophisticated studies. When Exxon was, being heard, the Exxon Valdez oil spill with Alaska, there were like 100 and something studies done. Well, that's just not going to happen in this case, right? The other problem is that experts argued that there were other sources of pollution, that it wasn't just Texaco. For example, raw sewage was being dumped into the rivers, and that had nothing to do with Texaco. So what that means is it's hard to really know the extent of Texaco's damage. So sure, water's getting dirtier, and some of it came from Texaco, but some of it may have come from other bad environmental practices from other companies. How do we know what damage is really from Texaco? So that makes this a lot messier. All right, issue 2. So we've talked about issue 1. Now let's talk about issue 2. Chevron has several settlement and release agreements signed by the government of Ecuador. All right. So remember, issue 1 was, hey, we're in a bilateral treaty and government can't sue us if we're Chevron. Issue 2 is that on top of this bilateral treaty, Chevron has several settlement and release agreements signed by the government. Well, what do I mean by settlement and release agreements? Well, these were documents that absolved Texaco and now Chevron from financial liability associated with collective action in Ecuador. Remember, one of the first things we talked about is that they agreed that $40 million, Texaco, $40 million would come and clean up the oil spills and then be absolved of any further liability. And they have documents. They're not stupid, right? They're going to say, okay, I'll agree to this, but you're going to sign all kinds of documents. All right, so issue number 1, there's a bilateral treaty where Ecuador's government can't sue Chevron. Issue number 2, Texaco, now Chevron, has these documents that say, hey, we're releasing these companies from financial liability. All right, so Texaco is protected, Texaco Chevron is protected from class action lawsuits. And related to that, they're protected from these collective damages that would come from class action lawsuits. So they're protected from class action lawsuits, and they're protected from these huge settlements that would come from a class action lawsuit. Now, if you don't know what I mean by a class action lawsuit, you probably have seen reference to these on TVs. This would be a whole group of people that were affected. So sometimes you see these on TV, they were saying, did you receive this kind of medical procedure and now you're having problems? Contact us because we're putting together a class action lawsuit. So this would be a whole collection of people that are united by some claim. And they would go after some kind of big award, collective damages. All right, so issue 1 again, there's a bilateral treaty. Issue 2, Texaco, now Chevron, has these documents that has absolved them from any further liability. So this means, for example, the Kofani indigenous tribe collectively cannot sue Texaco, I should be saying Chevron, for damages. Okay, that would be a class action lawsuit, and Texaco and Chevron have been protected from those. So now we're in 2013, and the arbitration panel agreed. So they agreed that the settlement and release agreements release Texaco, we're supposed to be saying Chevron, my bad, so sorry, Texaco, Chevron, and its affiliates of any liability for all public interest or collective environmental claims. So the arbitration panel said, you know what? Texaco/Chevron is correct. They have these documents. They are protected. And the Lago Agrio plaintiffs, lawyers, now you saw the Lago Agrio plaintiffs and their lawyers in the crude video. They've repeatedly admitted, and the judgment makes clear that the claims are exclusively collective and non-individual. So what does all that mean? Well, Lago Agrio, that lawsuit, they basically were saying, this is a collective lawsuit. This is a collective lawsuit. But the first bullet says, hey, Chevron's right. They're protected from these collective lawsuits. They're protected from class action lawsuits. All right. So this is obviously to the benefit of Chevron, right? In 2015, the arbitration panel makes clear that this does not bar claims by individuals. So this has been reiterated, remember, in an earlier decision. But bottom line, what we're saying here is, yeah, the arbitration panel says we agree, no class action lawsuits. We cannot have any of those because Chevron is protected. But, as the last bullet says, individuals can sue. Okay. So Chevron has definitely won some rounds here, right? They've won some rounds in that no one can have a class action lawsuit and government can't sue them because of the bilateral treaty. So back to Chevron v. Ecuador. In 2008, Chevron files in the U.S. District Court of New York. Okay, remember that there was already a lawsuit going on in Ecuador, and now Chevron's filing a lawsuit in New York. So you've got simultaneous lawsuits going on. What are they trying to do? They're seeking an injunction blocking enforcement of the judgment anywhere outside of Ecuador. All right, now that's important. Why does Chevron need to block enforcement outside of Ecuador? Make sure you understand what this is saying. This is saying, hey, whatever happens inside Ecuador, you can't go outside of Ecuador to try to apply a judgment. Now, why would Chevron do this? Well, Chevron has only $200 million in assets in Ecuador. So what they're saying is that, hey, if we lose and we lose everything in Ecuador, they can go after $200 million in Ecuador. But let's block them from being able to go after our assets in other countries. $200 million is not very much money to Chevron. But outside of Ecuador, Chevron's sitting on a whole lot of money and they're trying to protect it. So it's easy to predict here that Ecuador is going to go elsewhere looking for Chevron assets. Do you think Ecuador is going to settle for $200 million? Of course not. That's not near enough to clean up the damage. So Ecuador is going to go to other countries trying to get Chevron assets. So this is something that Chevron wants to try to prevent. So what Chevron's doing can be seen as a preemptive strike before the judgment. So the judgment, remember, it's 2008, and the judgment hasn't come out yet. So they're basically saying, whatever happens, if we lose in Ecuador, we want the courts to prevent Ecuador from going after our assets in other countries like Canada, United States, etc. This also somewhat suggests that Chevron's expecting the verdict to go against them. Remember, this is before we even know the initial verdict in what I keep calling the big case. If Chevron can show that Ecuador is corrupt, then it's easier to win a case to vacate or dismiss the judgment. So that's going to be another angle, right? So if Chevron can show that Ecuador is corrupt, then they might be able to get the judgment thrown out. All right, so you see where this is going? Make sure you're clear that at this point we don't know the judgment, we don't know the outcome. So these are preemptive things that Chevron is doing. Now, Chevron receives their injunction from Judge Lewis Kaplan. We don't care about the name, but what we do care about is that Chevron receives the injunction. They win in terms of keeping Ecuador from going after its assets outside of Ecuador, right? So this is good news because it's going to allow Chevron to protect the bulk of their assets because, as we just said, they don't have a whole lot inside Ecuador. Most of their money is outside of Ecuador. And now Judge Lewis Kaplan saying Ecuador cannot go after the money outside of Ecuador. So big win. But the Second Court of Appeals overturns this decision, and it specifically says that Ecuador can file in Canada, Brazil, and Argentina to collect on the verdict. So this is now bad news for Chevron, am I right? Because now Ecuador can go looking for assets in a bunch of other countries. So now Chevron's assets are not as protected as they were. And this is exactly what Ecuador does. So what we're going to talk about next is Ecuador going to Canada, to Argentina, to Brazil, and from there we'll talk about the corruption cases. Chevron trying to claim corruption charges. All right, hope you're still with me. I know this is a lot. So let's talk about Canada. 2012, Ecuador files a lawsuit in Canada to collect on the verdict against Chevron assets in Canada. So Ecuador is basically suing inside Canada. They want to get some of the assets in Canada because Chevron operates in Canada. A year later in 2013, an Ontario Superior Court ruled that Canadian courts have no jurisdiction over an Ecuadorian verdict. So wait a minute. In 12, Ecuador was proceeding with lawsuits in Canada, but just a year later, 2013, bad news, the Superior Court said, no, wait a minute, they can't do that. Canadian courts can't be hearing a case that really is an Ecuadorian verdict. But then the Ontario Courts of Appeals overturns this ruling as well. All right, so it's like flip-flopped. So first bullet, Ecuador can go after Canadian assets. Second, Superior Court says, no, you can't. Third bullet, the Ontario Court of Appeals says, yes, you can. All right, so now where are we? Ecuador can go after Chevron's assets in Canada. Now, this is bad news for Chevron. Am I right? They're absolutely not happy with this. So they're going to appeal this. And my research suggests that this has gone in favor of Chevron. So before the appeal, Ecuador had won this battle. Chevron appeals. Looks like Chevron's won. In January of 2017, the Superior Court of Justice ruled Chevron Canada is a separate entity from Chevron Corporation. And because it's a separate entity, it's not party to the Ecuadorian judgment. So, 2017, Chevron wins this round in Canada. Ecuador cannot go after Canadian assets for Chevron. However, there were some small wins for the indigenous people, and they plan to appeal. There was really language that Chevron wanted thrown out, but the court said no. So that kind of gave the indigenous people a little bit of hope, but basically at this point, Chevron's won this battle. Ecuador cannot collect in Canada. Now let's move to Argentina. Commercial Court of Justice in Buenos Aires freezes all of Chevron's assets in Argentina. Okay, so Chevron's operating in Argentina, and their assets get frozen by the courts. But then 2013, the Supreme Court revoked this action, so that was overturned. That then essentially lifts the embargo on the assets and future income of Chevron Corp's Argentinian subsidiary. That's a lot. What you really need to understand is this is a victory for Chevron. So, think about what just happened. Canada, Chevron wins. Argentina, Chevron wins. Now we're in Brazil. 2012, Ecuador files suit in the Superior Tribunal of Justice in Brazil's capital of Brasilia. Again, what's Ecuador trying to do? They want to seize Chevron assets in Brazil to pay on the verdict. So Chevron's operating in Brazil. That means they have assets in Brazil. Ecuador wants those assets in Brazil. A Brazilian attorney for Ecuador claims the Superior Tribunal of Justice will only analyze whether the Ecuador decision meets the requirements of Brazilian law for enforcement of foreign judgment. All right, so that's not a conclusion. What I have found, and I have not done enough reading on this, but I don't think anything else has come out of Brazil. According to Dr. Carver, the law is very slow down south, so Brazil might still be in the works. So who knows? So think about what's happening here. Ecuador is going after Chevron assets in Canada, unsuccessful. In Argentina, unsuccessful. In Brazil, doesn't appear to be successful. So this is not boding well for Ecuador, right? So let's talk about one last legal term, and that is racketeering, because this is going to become relevant in the corruption charges. Remember I said earlier that if Chevron can show corruption, then that makes it a lot easier to get the judgment thrown out. So let's talk about racketeering. A racket is a service that is fraudulently offered to solve a problem. Fraudulently offered to solve a problem. Such as for a problem that does not actually exist. So I'm kind of fraudulently offering to solve a problem when there's not really a problem to solve. Or where the potential problem may be caused by the same party that offers to solve it. So I cause you a problem and I then offer to solve your problem. For money, of course. So what might be an example of this? Well, let's talk about the mob. A small business is asked to pay protection money to the mob. Well, you're being offered a service of being protected by the mob. That's what they're selling you, protection services from the mob. But you're essentially protecting yourself from the mob. So the mob is protecting you from the mob. That's a racket. Of course, you're not going to need the services if the racket didn't exist in the first place. If the mob wasn't messing with you, you wouldn't need the mob's services. So that's what it means when we say you wouldn't need the service if the racket did not exist. So this example illustrates the idea of racket, and this is relevant in the next case. So the next case is Chevron v. Donziger. Well, in 2011, Chevron files racketeering charges against Donziger. He's, and et al., mean the others, the other attorneys. So Donziger, remember, is the attorney for Ecuador in the main case. So what's going on here is that Chevron's trying to show corruption on the part of the lawyers for Ecuador. This includes Stephen Donziger. Again, he's that New York lawyer that you saw in the Crude movie, Pablo Fajardo, and Luis Yanza. Now, so there's three of them. This is just 13 days before the verdict is entered in the original case in Ecuador. So this is kind of like a, midnight hour kind of lawsuit. So clearly strategic. Chevron's tactic here, as we've said, show fraud and corruption by Ecuador's lawyers. And possibly this suggests that Chevron thinks the verdict will go against them. So this is kind of like a plan B. They think maybe it's not going to go well, so they decide to sue the lawyers for Ecuador. They're going to show that they're corrupt, that there was racketeering, and then it will make it easier to get the verdict vacated, thrown out down the road. So they think they might lose, so let's go with this plan B. We're going to show that the Ecuador's lawyers are corrupt, and when we do, then we can get this verdict thrown out later. Now, 2014, the U.S. District Court finds Donziger et al. It finds that they committed egregious fraud. And this is in a U.S. District Court, right? This is not an Ecuadorian court. This is in U.S. District Court. And remember, these are the lawyers for Ecuador, but it's New York lawyers, okay? All right, so the U.S. District Court finds Donziger and his colleagues that they committed egregious fraud. For example, testimony from an Ecuadorian judge and experts hired by Donziger and others all speak to the following things. They speak to bribes, and they speak to falsification of reports, they speak to fabrication of evidence, and they speak to threats. So you've got an Ecuadorian judge and experts that were hired by Donziger saying, yeah, there were bribes, false reports, made up evidence, and threats. Okay, that's not going to look good for Donziger and his pals from New York, right? The district court found that Donziger used pressure, humiliation, and intimidation. That was one of the findings. And this pressure, humiliation, and intimidation included personal and professional attacks on anyone who did not agree with their position. Now, it must have been at a high enough degree where it would be a legal issue. So, pressure, humiliation, intimidation, personal and professional attacks, making up numbers that weren't supported by witnesses. They were accused of or found to have bullied witnesses, bullied experts, and that Donziger personally selected neutral court experts, that he bribed judges with promises of a percentage of the financial compensation from the verdict. So that's a big deal, right? So bribing the judges and saying, hey, we'll give you 5% of the verdict. All right. So it's getting really messy here. Was there corruption related to the verdict in the Ecuador versus Chevron lawsuit? Well, Chevron submitted documentation suggesting, yes, there was corruption related to the verdict in the Ecuador versus Chevron lawsuit. The technical experts went through the computer files of the judge. We don't care about his name, but the judge was Nicholas Zambrano. And the computer experts went through all of the computer files of this judge, the judge that heard the case, and they could not find any evidence that he actually wrote his own verdict. So basically the idea was that, hey, if he wrote this verdict, there would be some paper trail on his computer. But the tech experts couldn't find any drafts of the verdict. They couldn't find any notes related to the verdict. And so the conclusion was that it suggested that he did not write the verdict. All right, this is problematic. So the judge on the case does not appear to have written the verdict. So hopefully you understand what I'm talking about. Think about what you know about the Supreme Court. When the Supreme Court makes a verdict, each of the justices have to, kind of put together their own thoughts and notes, and a verdict document is created where you can read the decision and all of the logic. So basically, that would be an important role of the judge in this case. And this would be a huge document, right? This case has been going on for a really long time. So the fact that, the suggestion that he did not write it, that is really troubling. The judge testified in Chevron v. Donziger. So he was brought in. Remember, the judge from the Ecuador versus Chevron case, the big lawsuit, is brought into this corruption lawsuit that Chevron has against Ecuador's lawyers. And everything we're reading suggests that this this judge could not answer even basic questions about the verdict. So it's really seeming like this judge didn't write his own verdict, that somebody else wrote the verdict in the big lawsuit between Ecuador and Chevron. Now, in the international arbitration process initiated by Chevron, remember this would have been against Ecuador, experts from both parties agree that Judge Nicholas Zambrano did not write the final judgment in Ecuador versus Chevron. So, at the international arbitration process, when they sat down, both teams said, you know what, Judge Zambrano did not write the final judgment. So everyone's in an agreement that, hey, he did not write this. So the accusation is that Donziger, again, the New York lawyer and his team from New York for Ecuador, remember that Ecuador's lawyers paid Zambrano $500,000 to be allowed to write the judgment. So what that's basically saying is that Donziger bribed the judge to be allowed to write the judgment, that Donziger wrote the judgment that should have come from the judge. And remember, Donziger's a lawyer for Ecuador. This is particularly troublesome. Now, most of the charges in this case, Chevron v. Donziger, were directed at Donziger. But remember, there were 3 people involved in this lawsuit, Fajardo and Llanza. They had to also be listed in order to make any charges of conspiracy, right? Conspiracy requires more than one person. So Donziger, Fajardo, and Llanza are all named in this lawsuit. And they have to be named in order to bring charges if evidence is found against them. So if they find evidence against, let's say, Fajardo, but Fajardo was never named in the lawsuit, well, now you can't go after him, but he was named. However, it doesn't appear that Chevron's really after Fajardo and Llanza. It seems like they're all about Donziger. Now, Chevron wins this case against Donziger. But one important thing, so again, we're talking about this case of corruption and racketeering. But this is a civil case, and no criminal charges have been followed. So right now it's civil, and you understand the difference. Civil is about settling for money. Criminal charges could result in Donziger going to jail. Donziger, at least when I was researching this, had not been disbarred. I don't know if he has. I don't think so. But there is a financial judgment against Donziger because, again, it's a civil case. But likely this was not about money for Chevron, right? I mean, think about it. How much money could you really get out of Donziger? I mean, he's a rich lawyer, but he's got nothing compared to Chevron, right? So whatever the settlement was, whatever the financial judgment against Donziger is, it wasn't going to be a lot of money for Chevron. Instead, Chevron needed to win this case. Remember what we've said many times. Why did Chevron need to win this case? Because if they can show that Ecuador's lawyers were sleazy, then it's easier to vacate a judgment against them in the big case. So this was really important for them to win. So again, why do they need to win? Because it will help them vacate or have thrown out a judgment against them in the big case with Ecuador. So Chevron is using this as a strategy that if they lose the big case, they can say, yeah, but you know what? Look at the corruption. This wasn't even a fair case. So now let's talk about the idea of racketeering. Ecuador had indemnified Texaco from financial liability associated with collective action, right? We had talked about that when we said there were 2 issues. Issue 1, the bilateral treaty. Issue 2, Ecuador had indemnified Texaco from financial liability in, early on, close to 1993, when Texaco leaves, they agree to $40 million in cleanup as long as they were indemnified. So remember that way back at the beginning of this presentation. So Ecuador had indemnified Texaco from financial liability, but then Ecuador sued Texaco, right? That was that 1993 lawsuit before Chevron acquired Texaco. So what they're arguing is that Ecuador created a problem, but they would be the ones to profit with a big settlement if successful. So this sounds like racketeering, right? It's technically racketeering. So Ecuador indemnifies Texaco, then later sues them. So Ecuador creates a problem that they can profit from. So that was why they were claiming racketeering. All right. Now, Donzinger's not alone in all this. Chevron's lawyer doesn't look to be so squeaky clean either. We haven't talked about any of the Chevron lawyers. Randy Mastro, he's partner at Gibson Dunn. We don't care about that. He also appears to be a little dirty. There's suggestions that he offered a $1 billion bribe to the Ecuadorian government to quash the case. Basically, throw it out, $1 billion bribe. He advises non-settlements and extensions of the case, and so causing problems with it moving rapidly. He also intimidates, harasses, and is unnecessarily aggressive with witnesses. So again, sounds like what Donzinger was accused of. And other jurists have blasted Mastro's tactics. So they've kind of come out and said, hey, there were issues there. He was aggressive with judges to the point of being told to sit down. He blocks the release of documents. He was sanctioned by the courts for unethical behavior. And he filed frivolous lawsuits. All right. So again, it seems like all lawyers behave this way, right? But this is basically suggesting that Chevron's lawyers weren't squeaky clean either. Now, the thing to remember here, Donzinger has been sued in a court of law, but Mastro has not been sued in a court of law at the time I wrote this, and I don't think he has at this point either. He's only been sanctioned by a court he was arguing a case in. So basically, he was sanctioned while he was in court because he was behaving badly. But Donzinger's actually been sued. So there's some question about, could there be more charges in the future? Could Mastro be dragged into this whole corruption thing? Who knows? Maybe. So where the case stands now. For all intents and purposes, the Ecuador versus Chevron case and judgment is defunct. I mean, basically, it's dead. The suit against Donzinger shows fraud, and enough fraud to get the judgment vacated. So that's not good for Ecuador. And the judgment in Ecuador is still good and it's alive, but little is being done to enforce it. So basically, it's for all practical purposes dead. There's no way to enforce the judgment that is live, and the Donzinger case shows fraud, which could get the live judgment that's still alive vacated. So basically, Ecuador doesn't look like they're going to get anything out of this. They're just not going to be successful. Now, The Hague, remember our arbitrators, that they have shut it down internationally. And the Superior Court in New York has shut it down in the United States. So there's not going to be any more international arbitration. There's not going to be any lawsuit in New York. The Argentina Supreme Court shut it down there. Canada, I should have updated that. Canada, I said it wasn't quite done, but I just did my research. Canada is done, right? But there will be appeals, so it's not quite done. But Chevron won the first round in Canada, So it's, for all practical purposes, shut down in Canada unless the indigenous people are successful upon appeal. Brazil doesn't seem eager to pursue the case. And Ecuador has only confiscated $200 million. And where did that $200 million come from? That's the money that Chevron had in Ecuador. But remember what happened? Chevron tried to go outside of Ecuador to Canada, to Brazil, to get the resources that Chevron had there, and they've been shut down. So Ecuador's not faring well here. They've got the $200 million that was in Ecuador, and they don't have the ability to really go after anything else. Well, hopefully you appreciate that this lawsuit has been incredibly complex. And again, I don't expect you to follow the entire timeline. Don't memorize the dates, but you do need to have a decent understanding of the kinds of events that took place. Now, as we travel in Ecuador, we're going to see lots of anti-Texaco Chevron graffiti. Remember, some of it will say Texaco because Texaco was the one that actually did the damage, but Texaco was absorbed by Chevron, and so this becomes a lawsuit with Chevron. Now, obviously, Ecuadorians want the company to pay the reparations because remember, Ecuador won the initial lawsuit with a big judgment, and then it all fell apart, right? And obviously, Ecuadorians want to restore the environment. The damage has been significant. Of course, continued oil exploration in Ecuador is simply making it worse. We're going to be learning a lot about that. So look for some possible articles with updates on these legal battles. If there was anything that I didn't include in the lecture because I missed some kind of resolution, then I might post it to Canvas for you to take a look at. I hope you found that informative, and let me know if you have any questions at all. If they're really, really technical with a legal twist, I'm going to have to get Dr. Carver involved, but I'm certainly happy to do that. Thank you so much for listening, and have a fantastic day.